And what is also of significance, Your Worship, if the applicant was not residing there and the owner, according to the municipality, did not know that that applicant is there, he would have been out of that place. His assets are there, meaning that between whoever this Albert who signed the lease and the owner, there's knowledge about the applicant living there. We've had instances where people applied to be released on bail who live in informal settlements. You can't even pin a location. But those people are admitted to bail and they're given an opportunity to attend to court outside. Now, Your Worship, there was also an issue with regards to previous convictions. The applicant made mention of two. He made mention of 3 previous convictions. And the state made mention of 5 previous convictions. 6, Your Worship. Your Worship, the submission is that the 3 that were mentioned by the state that the applicant didn't mention, he gave a plausible explanation to the court. And he informed the court that all of them, a fine was imposed and he did not serve any direct imprisonment. Hence, on his limited understanding, that did not make a previous conviction. I'll invite the court to look at the reality that the applicant is a lay person. And accommodate the applicant in as far as the possibility of making errors, especially because these previous convictions are fines and he wasn't incarcerated for them. I further invite the court to find that that omission was not mala fide. Your Worship, on the charges, the applicant is charged with defeating the ends of justice, possession of a firearm, which is a 9mm firearm, possession of ammunition for a 9mm, and discharging a firearm in public. My submission is that on the defeating the ends of justice, even on the case law, nobody has ever gotten a lengthy term of imprisonment. The general notion is that 3 years, if a court finds someone guilty, is a sentence that is handed out by the court. Now, Your Worship, on the aspect of a firearm, the definition of the state does not define that 9mm to be a semi-automatic firearm. My submission is that in the absence of it being a semi-automatic firearm, it does not invite the imposition of a minimum sentence. On the issue of ammunition, Your Worship, I'll refer the court to the case of State versus Mieni. It's a ZAGP JHC 368, where the court imposed a sentence of 2 years. Now, Your Worship, let's look at these sentences that I've referred to the court holistically. They are not lengthy sentences. They thus take away the ability to incite the applicant to evade his trial. I do not see a reason, in light of the charges that have been proffered, why the applicant will evade his trial on the likelihood of sentence. Your Worship, the state in its papers also confirms that the applicant does have a business, because at some point the investigating officer went to the business premises. Needless to say that that business is situated on tribal land. It's a business that runs and it generates an income. And the income that it generates contributes to the estate of the applicant before court. He's married. He handed over his passport to the investigating officer. That is also behavior that is inclining towards being honest. There is no need for the court to find that he is a flight risk. When he was called to the Majanga Commission, he appeared as he was requested on all occasions. He even, except for when he was sick, Your Worship, he did not make himself available. Your Worship, he also availed himself before the parliamentary committee when he was invited to do so. Your Worship, the submission is that the applicant before court has made a proper case, and he has demonstrated that the interests of justice permit his release on bail. Bail, Your Worship, is a contract between the applicant and the court that if he pays X amount of money, the amount that he pays ought to give him a reason to come and appear in court. Having said that, Your Worship, the amount of bail is solely within the prerogative of the court. The court can order an amount as it deems fit, and the court may further add any conditions which it would like the applicant to adhere to. He still enjoys his right to be presumed innocent. Your Worship, may I take an instruction? As the court pleases, thank you, Your Worship. Your Worship, further thereto, there were allegations before this court that the applicant attempted to bribe the investigating officer. and I believe it to be prudent that submissions are made in that regard. The applicant before court denies the allegation of bribery. The arrest of the applicant was in the presence of numerous police officials and media personnel. And at no stage was the applicant alone with the investigating officer. Further thereto, Your Worship, that allegation is unsupported by independent evidence, recordings, or corroboration, or witness confirmation. We therefore invite the court to look into this allegation with caution. What we are bringing to the court is not a determination on the guilt of the applicant, but whether or not the interests of justice permit his release on bail. The facts that the applicant placed before court remain uncontested. And together with the other submissions that the applicant has made, a proper case that he be admitted to bail and that he has passed the test for the interests of justice, the court ought to find in favor of the applicant. Your Worship, I have dealt with the issue of bail conditions. I've also dealt with the issue of the bail amount. The applicant had, however, informed the court that he would afford bail in the amount of 10,000 rands. Your Worship, my submission on that amount is that that falls strictly within the ambit of the court. The court is not bound by the amount that the applicant requests, and the court may order as it deems fit. Your Worship, the applicant has demonstrated that no ground exists under Section 64A to E warranting continued detention, and that he be released on bail. Your Worship, the heads of argument that are dated the 28th of May. May I inquire from the court, is there any aspect upon which the court would like me to address it on? As the court pleases.
Your Worship, I'm not going to regurgitate the submissions which have already been made by counsel in relation to this particular bail application. Your Worship, the principles in relation to bail have already been adequately outlined by counsel. What I am going to do is just to touch base on some of the aspects that the applicant wishes for this court to be aware of. It's just for the purpose of clarity. Your Worship will remember that from the submissions by the investigating officer is that there is an issue in relation to the address which renders the applicant a flight risk. Now, there is this aspect in relation to the number, not necessarily the area or the street number or the street name. There is an issue relating to the number. Now, the number that the investigating officer says he obtained recently, it's 4544. The name of the street is the same. The area is the same. The number which has been provided in the lease agreement, in the proof of residence from the Barolong Batsidi, the affidavit of the wife, is different to the extent that it starts with 4454. So it is just a mistake, an error, and one can argue that it's an honest error.
Which one is correct?
Your Worship will note that the correct one will be the one which is 4544, which was confirmed. 4544, yes, which was confirmed by the wife of the applicant in this matter. And this is according to the investigating officer's statement that when they arrived, she produced the lease agreement, and when we look at the lease agreement, it refers to 4454 and not 4544. Now, it is clear that the applicant's wife clarified this, just so that it is clear that the investigating officer initially, in his statement, he went to number 4454, where he found initially, in the first affidavit, he went to 4454, where he found Ms. Tandiwe. Just want to get that name correctly. I don't want to mislead the court. Yes, Tandiwe Sinukwani. Now, what is important, Your Worship, is that all these numbers are in the same area. It is
Area, same street.
same street. It is the matter of just one having made an error which one can also argue that it's an honest error. It is clear that the applicant's wife was under the impression when she went and submitted the affidavit, and also when they went and obtained the proof of residence, that where they are staying in terms of the lease agreement, it's 4454 and not 4544. So it is just a technical error. But the fact of the matter, Your Worship, is that there is an address, and that particular address exists. And the investigating officer was not misled in terms of that particular address. He went and found this particular address. Now, there is nothing from the investigating officer that says he further made investigations around that particular area, and this investigation resulted in a finding that the applicant does not reside in that particular address, which it has been given to him. He may be dissatisfied that he found minimal items, but that cannot be a ground to say that a person is a flight risk or does not reside there. Is there a formula in terms of the number of items that you need to find in a particular area or in a particular house? Because a person can have 3 items or 4 items, but that doesn't necessarily mean that they do not stay there. Pictures were taken. It is a house, it's a property, a fixed property, a fixed address. Now, I just wanted to clarify that because it appears that it borders on the court asking itself that will the applicant be easily traceable under the circumstances? My plea with the court is for the court not to look at that particular issue in isolation, but as my counsel has already submitted, must look at the address together with this business address, which was positively confirmed by the investigating officer in this matter. In his statement, he says he found a passerby who he asked he asked the applicant regarding the information regarding the applicant, and this passerby directed him to this particular restaurant or liquor outlet where it's named Old School. But the fact of the matter is that when he got there, he found someone, a lady which is a receptionist, and that particular person gave the applicant's number. That is where they actually managed to phone the applicant. Now, the applicant is not a foreign national, wherein we would say that he actually would have even any inclination to actually flee the Republic of South Africa. We're dealing with a South African citizen. In his affidavit, he has indicated that he was born in Mafikeng. The details of the mother, the details of the father, they've been placed in his affidavit. Further to that, Your Worship, the applicant is not someone that one can say that can easily disappear. It is not possible. He's very well known. He's been in the public. He's in TV. If he disappears anywhere in South Africa, he will be easily traceable, unless if the court or unless if the state is saying that they do not have enough resources to actually trace the applicant in this matter, which I believe not. The state is very much equipped. We have intelligence in the Republic of South Africa that can actually easily locate the applicant if he disappears. Now, as he has indicated in his affidavit, Your Worship, the applicant, he further says the warrant was issued on the 17th, or rather signed on the 20th of April. On the 29th of April, and that is not a dispute. On the 29th, he was at the commission. He attended to the commission. He could have been easily traced. On the 15th again of May, he went and attended to the commission. Now, when we look at that, would we say that someone who attended the commission, and as my counsel has already submitted, as well as the ad hoc committee, can decide and to disrespect this particular court and evade trial? It is not possible. Actually, the argument, if there is any such argument, it's baseless. And he has kids, Your Worship. He has children. He has indicated that he has 4 children. And what the investigating officer doesn't also tell this court is that he confirmed that those particular children reside there, at that particular address where the applicant has indicated. Because if the court will remember the annexure, which is the affidavit of the applicant's wife, it clearly specifies that I reside in this particular address with my 3 children. It is there. Now, why would the applicant decide not only to abandon his children but to also evade bail when he has such strong family ties in the Republic of South Africa? It doesn't really make sense. And as my counsel has already submitted, the seriousness of the charges that the applicant is facing is not such that will actually give him any inclination to actually evade his trial. It's not like he's facing minimum sentences. And regarding the previous convictions, now, if the applicant did not want to, rather to mislead this particular court, so that he can actually obtain favor in relation to a bail application, he would have decided that he is not going to even disclose any of the previous convictions. Now, such a disclosure by the applicant in this matter, it shows that he was playing open cards. It is, however, as it was argued by my counsel, that he omitted those particular previous convictions which were less serious and he was not subjected to a direct imprisonment. The court will note that the last previous conviction, it was in 2012. That is over 10 years since the applicant in this matter had any brush with the law. It is clear that when we have regard to the submissions which were made by the investigating officer in his affidavit regarding why bail should not be granted, when we look at the person of the accused of the applicant in this matter, those particular grounds which have been submitted by the investigating officer do not have any merit. And further to those particular previous convictions, they are all unrelated to this particular matter. They do not create a pattern in relation to a conduct of the applicant in this matter. Your Worship will note that the case against the applicant, more so regarding the staging of the assassination attempt. This particular case, from the evidence which has been submitted by the state, it's relying on ballistics, it's relying on CCTV footage, and a witness. All we have to do right now is that it's not necessarily to say that there is a prima facie case against the applicant in this matter. That is a trial issue. This court is not enjoined to actually determine the guilt of the applicant in this matter. There is case law in relation to that. Those are triable issues which the applicant will, at the correct forum, object, discredit, and show that particular court that there is actually no case that the state has actually established against him in this matter. Now, an applicant cannot say he is a violent person. The cases are dated 10 years ago. We cannot say that that is a danger to the public, as it has actually been averred by the investigating officer in the affidavit. The investigating officer in his own affidavit further says that from the evidence that we have, there was no one inside the vehicle when these shots were fired. Now, you cannot then say that this person is a violent person when the alleged shots were fired when there is no one, or these shots were not directed at anyone. Now, when we look at the submissions which have been made, there is a particular impression that has been created by the investigating officer that the applicant is an untrustworthy person. And this can be found in paragraph 20 of the investigating officer's affidavit. Perhaps one should actually start in paragraph 16, where the investigating officer indicates that he visited the applicant's address on the 3rd of March, or the business address, my apologies, the business address on the 3rd of March. And when we go further, there is something that the court will note from the applicant's own affidavit. Says, I had my skepticism about this person actually being a police officer who was contacting me. And when we look at the fact that there's been a history in relation to the applicant, wherein there was an alleged illegal raid in November, there was an attempted assassination, that is according to him, in December. Now on the 3rd of March, and he is under protection because of the Matlanga Commission. On the 3rd of March, a person purporting to be an investigating officer, a person who is unknown to him, contacts him. We cannot say that for the mere fact that the applicant was reluctant to actually meet with the investigating officer, that means that the applicant is an untrustworthy person. He was reluctant based on the history of events which happened prior to the contacting by the investigating officer. That is where the reluctance emanates. Yes, it is correct that in paragraph 20, as the applicant, he did not deny paragraph 20 that there were communications between him and the investigating officer. He doesn't deny that. Even in his supplementary affidavit, he doesn't deny. But the issue is, the situation now is different because he knows who the investigating officer is. If the investigating officer now contacts the applicant in this matter, and the applicant is dodging and diving, then we can say that the applicant knowingly that he is dealing with the investigating officer is evading, or rather was avoiding the investigating officer in this matter. But then previously, that is something different, Your Worship. He had his reluctance, and his reluctance, Your Worship, I submit, was justified. Your Worship, I'm told that the applicant is asking that I should approach. May I just quickly approach Scott this session? Your Worship, he wanted me to just clarify a submission which was made in relation to the passport. He wanted to clarify that that particular passport, which we submitted a copy of, it's actually in possession of the wife. The original, yes. So I just recollected that there was a submission that the IO has already taken the passport. He just wanted me to clarify that particular point, that the passport is available. The passport is available upon his release. And if we can actually, I'm not sure if the IO dealt with the movement of the applicant in and out of the Republic of South Africa, but however, the applicant does not deny that he has moved out of the Republic of South Africa. But he says, I do not have relatives, I do not have assets outside the Republic of South Africa. So there are no financial or economic ties in those particular, or rather outside the Republic of South Africa. So he does not have any issues if a condition is placed that his passport actually be confiscated by the investigating officer in this matter. And in fact, should any need arise that perhaps he needs to use his passport, he will have to approach this particular court again, so that he should actually have the court to vary these particular conditions of his bail conditions regarding the passport. And those arrangements will be done with the knowledge of the court and the knowledge of the investigating officer in this matter. Now, I have dealt with the issue relating to the applicant, the meetings not materializing, and not necessarily meaning that the applicant is not a reliable person. Now, in paragraph 46.5 of the investigating officer's initial affidavit, the investigating officer, in trying to qualify that the applicant is an unreliable person, he goes further and says that in 2007, or rather a case in 2007, and also a case in 2006, there was an incident wherein the applicant could not be circulated, or rather there was a circulation because the applicant could not be found. I do not find this to be relevant to this particular bail application on the basis that, first, this is something which happened a very long time ago, and further to that, in 2012, the applicant was in court, tried, or rather he pleaded guilty to 2 charges of assault and 1 of reckless driving, and he was sentenced. That particular circulation fell away. It is not relevant, because if indeed he was circulated, as it has been averred by the investigating officer in paragraph 46.5, then they would have actually rearrested him and placed him on trial in relation to those particular circulation. And no such thing has ever happened. So that cannot find any relevance in relation to this particular bail application. The probability that he will abscond, it is not there at all. And what I like, Your Worship, is that investigations in this matter are complete. That is in paragraph 51 of the investigating officer's affidavit. There are no outstanding suspects. The matter is trial ready. There are no outstanding investigations, which perhaps the state can say they are worried that he will interfere with those particular investigations. So there is nothing which we can say that the applicant can actually influence. And in fact, when we look at ballistics evidence and the other evidence which has been allegedly collected by the state, it is now in the state's custody. And there is no inclination that the applicant can actually try and manipulate or influence that particular evidence. And further to that, most of the the witnesses, if one has regard to the investigating officer's statement, they are members of the police, most of the witnesses. So there is no way one can say that the applicant can undermine the rule of law or the functioning of the bail system as alleged by the investigating officer in paragraph 48.2. Now, in 48, the investigating officer mentions this issue of an attempted bribe or whatever. That is neither here or there, because in his own affidavit, he also further says that when he asked, the applicant said information. Needless to say that the applicant denies ever offering anything of a bribe, because when one looks at a bribe, the applicant would have actually said blatantly, or if there was any intention to bribe, the applicant would have blatantly said, can I give you money so that you can actually give me bail? That is now an attempt to bribe. So there was no offer which was made by the applicant in this matter. Which is why this particular issue in relation to a bribe was never even taken further by the investigating officer in this matter. The investigating officer in this matter is a colonel, someone who is highly ranked. He understands what is a criminal offense. He has been dealing with criminal offenses for over years, as indicated in the affidavit. So if he felt, or rather if there was an attempt, and he believes that this particular attempt was real, or rather there was an intention and there was unlawfulness, he would have actually taken it upon himself to immediately arrest or rather charge the applicant in this matter with a further charge over and above what he has already been charged with. So this particular averment in relation to this, it is just one of those particular elements which are basically being placed before the court to create this particular impression that the applicant is an unreliable person. Your Worship will note further that my learned colleague dealt with the principles of Dada Dlamini as Kitikat. What is important just to place on record is paragraph 11 of that particular Constitutional Court decision, which reads as follows, I quote, "Furthermore, a bail hearing is a unique judicial function. Also, although bail, like the trial, is essentially adversarial, the inquisitorial powers of the presiding officers are greater. An important point to note here about bail proceedings is so self-evident that it is often overlooked. It is that there is a fundamental difference between the objective of bail proceedings and that of the trial. In a bail application, the inquiry is not really concerned with the question of guilt. That is the task of the trial court. In a bail application, the inquiry is not really concerned with the question of guilt. That is the task of the trial court. The court hearing the bail application is concerned with the question of possible guilt only to the extent that it may bear on where the interests of justice lie in regard to bail. The focus at the bail stage is to decide whether the interests of justice permit the release of the accused person pending trial, and that entails the main protecting the investigation and prosecution of the case against hindrance. This basically, when we look at this particular quotation, is there any hindrance protecting the investigation? Based on the investigating officer's own statement, there is no hindrance whatsoever that may result in relation to granting bail to the applicant in this matter. Your Worship will further note that this particular principle relating to bail has been dealt with on many occasions, and I just want to highlight that there is also the principles as enunciated in the State versus Bacchus case. Now, I wish to also highlight the case of S versus Diale and another. It's a 2013 volume 2 SACR 85 at paragraph 14, where Ubushi J stated as follows, I quote, "A court cannot find that the refusal of bail is in the interest of justice merely because there is a risk or possibility that one or more of the consequences mentioned in section 60 sub 4 will result. The court must not grope in the dark and speculate. A finding on the probabilities must be made. Unless it can be found that one or more of the consequences will probably occur, detention of the accused is not in the interest of justice and the accused should be released." Close quote. Now, what this case basically confirms is that we do not have to look at this issue in relation to a flight risk as one of the elements, or rather determining factor, whether bail should be granted or not. We should look at all the personal circumstances, everything that is before the court. And the court, in determining whether there is any likelihood that the applicant will evade bail, must look at his personal circumstances, the seriousness of the charges. His family ties. Those are the aspects that the court needs to actually look at. Your Worship, the principles in relation to bail have been provided for in section 60 subsection 1A, which states as follows, I quote, "An accused who is in custody in respect of an offence shall, subject to the provisions of section 50 subsection 6, be entitled to be released on bail at any stage preceding his or her conviction in respect of such offence, if the court is satisfied that the interests of justice so permit." And a close quote. And those particular principles, they have been tested in section 60 subsection 4A to E. In closing, Your Worship, I would like to just regurgitate the S versus Branco case, which principle states as follows, I quote, "A bail application is not a trial. The prosecution is not required to close every loophole at the stage of proceedings. However, a factor favoring bail is whether the appellant has established a defense which has a reasonable prospect of success at the trial." Now, when we look at that in conjunction with the fact that the state reliance on this particular evidence, the witness, the cameras, without turning this particular court in a mini trial, I submit to Your Worship that the submissions which have been made by the investigating officer relating to the strength in the state case should actually be looked at objectively. And when we look at that particular evidence or rather submissions which have been made objectively, one will note that they are in direct contrast with the evidence which has been submitted by the applicant in his affidavit. Now, I wanted to go to Annexure AR02, but may I just Annexure AR02 to the investigating officer's statement. But before I do so, I beg leave just to approach the applicant in relation to this matter. Again, the sister is there, is listed. I can go on and on. But what I'm trying to say is what the investigating officer has done when he submitted this particular document is to confirm to the court that the applicant has strong family ties in the Republic of South Africa. That is what I'm trying to highlight. And this is not information that came with the applicant in this matter. Irrespective of the issue of the address or whatever, but we have a person who is South African, the family tree is there, the parents, the investigating officer is aware, and there's addresses, if the court can note this particular page 4. There's addresses of those particular relatives of the applicant in this matter. And none of those particular address is an address outside the Republic of South Africa. Your Worship, as I close, is there a possibility that the applicant will evade trial? I submit that no. Is there a possibility that the applicant will influence the investigation? I submit no. Are the charges against the applicant in this matter serious? I submit no. All the circumstances, Your Worship, which have been placed before the court are more favorable to the applicant in this matter. The applicant did not commit such a heinous crime wherein people were killed. No one died. What will he be running away from? We have seen serious offenses where people are charged with robbery aggravating circumstances, Schedule 6 offenses, premeditated murder, but the court still finds that these particular persons, provided that they have submitted exceptional circumstances, they still are being permitted to bail. Now, this particular applicant in this matter, facing such less serious offenses, why would he run away from these offenses? And further to the submission by counsel that bail is within the bail amount is within the prerogative of the applicant, I further submit, Your Worship, that the court should also be considerate of the personal circumstances of the applicant when the bail amount is considered, on the basis that he says he can be able to afford 10,000 rands. Any exorbitant amount, Your Worship, in light of the personal circumstances, can be tantamount to a refusal of bail, considering that this is what he says he can actually afford. And as I'm still on my feet, the court should be mindful of the fact that the wife of the, although in the investigating officer's affidavit, in paragraph 40 of the affidavit, he says that the applicant is never married. The court is mindful of the recognition of the Customary Marriages Act, and the applicant and the wife have both, under oath, indicated that they are married in terms of that particular customs. So which is the reason why in paragraph 40, the investigating officer did not find any records of the applicant in this matter. Your Worship, in paragraph 49, the investigating officer says that the public interest, or rather says the public order, will be undermined on the basis that the applicant frequently makes social media comments and posts, as well as mainstream media statements. That is one of the reasons that he indicates as the basis for bail being denied. Your Worship, I'm not sure if what is being insinuated here is that the applicant must refrain from exercising his freedom of speech, which is a right enshrined in the Constitution of the Republic of South Africa, because such a limit will be unconstitutional. And making public statements doesn't necessarily mean that it will undermine public order. So that particular submission is unfounded. Your Worship, subject to the submissions by the state, I believe that that is all that we have to submit at this stage on behalf of the applicant in this matter. Scott, please, Your Worship.
Before you,
Yes, Your Worship.
I just want to clarify this aspect. This key, location,
Correct, Your Worship.
it was provided by the applicant, correct?
That is correct.
And I take it that there is no dispute regarding that. This, according to the way you have provided to the state.
Your Worship, in fact, it was forwarded to me and it was provided by me to the investigating officer. And in the investigating officer's statement, he says he followed the pin and on the left, he found this particular property.
So that is the correct.
That is the correct pin. Yes, Your Worship.
And there is no dispute regarding the house.
There is no dispute regarding the house. And in fact, the pictures as they have been attached by the investigating officer are the same pictures that, even though he did not indicate it in the affidavit, I also forwarded him similar pictures. I'm not sure about the date, but I forwarded similar pictures. It might have been on the Monday when we were here in court, but similar pictures were forwarded to the investigating officer. Scott, please, Your Worship.
Thank you, Your Worship. Your Worship, the starting point of this application is that it is common cost that it is a Schedule 5 bail application. And in Schedule 5 bail application, the onus is on the applicant that he must discharge it to satisfy the Honorable Court that it will be in the interest of justice if the applicant is convicted. Your Worship, I will start off with Exhibit A, that is the statement of the applicant wherein he is applying for bail. Your Worship, he made mention of the address of 4454. And again, in Exhibit C, in paragraph 9, he insists that there is no problem of the address. There is no issue of the address. And my Lord, Your Worship, when we move further, we look at the annexure on Exhibit A. There's an annexure of the Barulong Bura Chili Traditional Council. The address that is given there is 4454. And when the police visited the address, they find the address which is on Exhibit B, the photographs that are marked as Exhibit ARO 6. This is presented to applicant. Applicant sees this. It doesn't say, no, this is the wrong house. You, in fact, went to a wrong house. This is not the house where I am staying. What the applicant is saying, the instruction that is given is that they need to go to another address, which is now a P. I then refer the Honorable Court to Exhibit D, where now the investigating officer visits now the area once more. And in Exhibit B, AR01 is attached, which is a lease agreement. The lease agreement says 4454. Your Worship, when we then look at this 4454 and we contrast it with Exhibit A, paragraph 5.5, it's 4454. It's the same address. Now, one would ask himself as to, is this all the mistake? Is it a mistake that all these addresses are not correct? Because when we go to further to Exhibit D, when the investigating officer asks as to what is the address on this property, and then I would refer the court to paragraph 11, Exhibit D, where the wife of the applicant says, she immediately, in fact the IO says, she immediately told me that the number is 4544. Now, does the lease agreement exist? The answer is no. Because the investigating officer had gone to, this is now for the second time, and it's also according to Exhibit D. The investigating officer had gone to 4544. Now we then move to other annexures that are attached on Exhibit D. Now this property is registered under 80 code. And we then look at the AR01, it's 01, I'm sorry, Worship, and it indicates that its landlord is Albert Moy Sapos. So it is clear that this property, these are two different properties. And the confirmation of the of the chief to say that he is in fact staying at 4454 is also incorrect. Is the chief also making a mistake? Your Worship, the submission from the respondent is that there is no mistake. This has been done deliberately. And Your Worship, if we also look at Exhibit B, this is the statement of the investigating officer, where the investigating officer indicates that this annexure, that is the statement of the wife of the applicant, she mentions the same address, 4454. Now the question is, how then do we know that the applicant is in fact staying at the address that he is saying that he's staying? Your Worship, it must be bear in mind that the onus is on the applicant. The onus is not on the state. Your Worship, in responding to what was said by my learned colleagues before this honorable court, is that the applicant holds a view that they are not a flight risk because they made themselves available at Maflanga Commission and as well as at ad hoc committee. But when the applicant was making himself available, he was just a witness. He was not a suspect or an accused person. And before this honorable court, he is appearing as an applicant, in brackets, an accused person. Now, when the investigating officer calls him, trying to obtain a warning statement from him, he is avoiding him. If the Honorable Court can look at Exhibit B and look at paragraph 16 up to 19, the applicant is being informed that I want a warning statement from you. And his response is that in Exhibit A, in responding to this, that he was skeptical. He was not sure whether this might be a police officer, but he can easily go to the police station, the nearest police station where he is, and indicate to this person that you are saying that you're a police officer. I am at this police station. Come and get a warning statement. He's not doing it. So that it is an indicative that he is in fact a flight risk because he knew that he is now in trouble. So he must avoid the police as much as he can. And in the matter of force majeure, where he is the complainant, the incident took place on the 3rd of November 2025. He gives his statement through an ATIM 10 days thereafter. This is a person who's fearing for his life. And in the statement, he does not give his personal details, so that when he is wanted to be informed about the development of the investigation, he should be easily contacted. He only indicates that this is attached to worship on Exhibit B, and it is marked as AR01. Your Worship, it is at that time when he was contacted by the police that he was aware that the police have now established that he is no longer a witness. It is upon the completion of the investigation that the investigating officer then registered the docket of defeating the of justice.
When was it registered?
Your Worship, it was registered in March. Your Worship, I would refer the Honourable Court to Exhibit D, if the Court looks at paragraph 3. Exhibit D. It's also in Exhibit B. It's a case docket of this year.
Just for a second, please.
That's a court basis.
Exhibit B or D?
Your Worship, it is in both exhibits, but I have found it on Exhibit D is paragraph 3, and then in Exhibit B it would be on paragraph. It's on paragraph 13 on Exhibit B.
It's reflecting other cases on paragraph in Exhibit B. But anyway, proceed our question.
Your Worship, I think Exhibit B13.
Now proceed with your understanding.
As a proposed. Your Worship, further to that, the Exhibit B of the investigating officer also indicates that at some stage the applicant made some utterances that he then concluded that it is a bribe. I submit that in itself shows that he may interfere with the administration of justice. And Your Worship, it was also indicated before this Honourable Court that he is linked with ballistic report, CCTV, and as well as a witness. It is incorrect to say a witness, it's witnesses. And it was further submitted before the court that The issue of circulation is neither here nor there. The state submit differently in that submission, in that there was an effort from the police. They had to circulate him to be able to get hold of him. Therefore, it is submitted that that is in fact relevant when it comes to a person being a flight risk. Further to that,
Just for a second, the issue of circulation, is it in relation to the police officer wanting to obtain the warning?
no. The issue of the circulation is the issue in Mabatu about the previous promotion cases. That for the police to try and get hold of him, they had to circulate, because it was not easy. They were unable to get hold of the applicant. That's why they had to circulate. May I proceed, Your Worship? Your Worship, it is also been submitted to this Honorable Court that the strength of the state case is weak. Your Worship, I differ with that. The submission that the state is making is that there are witnesses, eyewitnesses, showing they in fact saw the car being stopped and a person lighting from it and firing few shots towards the car. And at the time, the person who was driving the car, he was alone in the car. There was no passengers in the car. And the CCTV also indicates that there wasn't any other party that had tailed the applicant's motor vehicle. The applicant at the time, his car was the only car in the area. Your Worship, I would also want to submit that the reason that J50 was authorized and issued, it was because of the state was unable to get the applicant. Because at the time when the investigating officer had gone to Mabatu and also to his place of business, the investigating officer was only looking for a warning statement. It is then upon realizing that it is not possible for them to get hold of him so that they can obtain a warning statement. A warrant of arrest was then applied for, and it was then authorized by the legislature. Now, the only time or moment that was available for the state or the police officers to arrest the applicant, it was only after he had testified at the Masanga Commission. Because at the time, the state did not know where he stays. Because when you look at it, Exhibit B, Your Worship, there are a number of addresses there, which were visited by the investigating officer but could not get hold of the accused person, or rather the applicant.
Which addresses were visited when he was
Those that appear on the profile. Yes.
And at that stage, there was no address given, including the 4454.
There was no address. Your Worship, the address of the 44 address, it was only given during the first appearance. When the police officer wanted or requested the address from the applicant, at the time when the investigating officer was charging him, there was no address that was given that the investigating officer was able to verify. On that point of the address, Your Worship, it was further submitted that the address, the 44 and the 54 is on the same street. I just want to refer the Honourable Court to Exhibit D. Then on the Exhibit D, on AR01, the street there is 44. It's 4454 Mushi Street, Unit 13. And when one goes to the utility bill, which appears on the statement, which is marked as ARO 5. It's a different street. The street is, according to this, is Mohatha Close. So it differs. So it is not on the same street. Your Worship, it was also argued before this Honourable Court that the charges that the applicant is facing are not serious, and it was further indicated that they do not carry any minimum sentences. Your Worship, I beg to differ with that submission. If one looks at the charge sheet, count 1, which is unlawful possession of firearm. Your Worship, it is read together with 51, with section 51, 2 of the Criminal Law Amendment Act 5 of 1997. Therefore, it does attract the minimum sentence. And it was further argued that there is no indication as to whether that the firearm that was used is a semi-automatic. Well, the state is alleging it on count 1 and will then prove it during the trial. So I then submit that the charges that the appellant is facing are very serious. And further to that, I submit that the applicant did not discharge and Your Worship, I would refer the court to case basis. It's a state versus Moeti. It's a 1991 case, it's volume 1, SACR 464B, where Judge Handler J held at page 463, paragraph E to F, open quote, having considered the authorities, more particularly R versus September 1961, volume 3, SA 468D, State versus DW 1980, volume 4, SA 94, WLD, and S versus Williams 1991 1, SA 171 ZA. I am satisfied that for the applicant to succeed in this application, there is an onus upon him to show on the balance of probabilities that the interest of justice will not be prejudiced if bail is granted. Your Worship, I submit that if the Honourable Court is of the view that the applicant has discharged his honours, I would submit that when it comes to bail, it has been suggested by my learned colleague that the amount that the applicant can afford is an amount of 10,000 rand. I disagree with the amount. My counter submission thereto is that an appropriate amount would then be 100,000 rand. Your Worship, it was further, and further to that, the conditions, if the court transfers, the condition then should then be that he must report at the police station, and he must hand over his passport. That would be that with regard to conditions. It was also argued about the jurisdiction. Your Worship, this is a regional court, and the state submit that a regional court does have jurisdiction to try this matter, whether the matter is from Vosloorus, Soweto, and or Pretoria. It is within the region of Gauteng. Your Worship, it is indeed so that the defense were not informed as to why was the matter brought to Johannesburg regional court. Your Worship, I don't think that would be relevant at this stage. Even they will be informed as to why was the matter brought to to this court. Your Worship, if I may just comment on that, this court is a big court. That's why permission was asked that the matter should in fact be brought to this court, so that if the matter proceeds, and then the trial can be finalized as quickly as possible. Your Worship, that will be all unless if the Honourable Court wants to hear me on any other aspect. In a nutshell, Your Worship, the state is still opposing. As a constitution.
I have two questions.
Two questions. Thank you.
I don't want to go deeper into the merits, but just clarify some aspects.
As a court witness.
The incident that happened at Kosovo's, it was the 3rd of November 2021.
That is correct.
When you addressed me now, you said after the incident, he never reported this, but after 10 days, he was submitting the affidavit to the
That is correct.
So I'll take it that there was no case opened by him.
Your Worship, there was a case that was opened by the police. The police opened a case because of what he told the police. So it was a hearsay case, and the case was not going to go any further without the statement.
The case was opened by the applicant reporting the incident.
Yes, and then the police then registered a docket to that effect. Should I maybe give one or two aspects to, or should I amplify that?
Just wait for my question. Exhibit A01.
It's an exhibit.
Exhibit. That is annexure into exhibit
Exhibit B. Is this?
A01.
Is my exhibit?
The statement of the investigating officer.
Savage.
You got it?
Yes,
So this annexure A01, that is what we have reported in the post orders 39/11/2020.
that is correct, Your Worship.
When he was traced to obtain the warning statement, is still in relate to case number 39/11/2020.
When he was traced to obtain a statement,
Warning statement.
a warning statement, it was in respect of the case that had now been registered, the new matter,
Which is
case number,
431.
yes.
And this is after the investigations regarding 391125.
That is in its operation.
Was there any firearm found in possession of the applicant? If yes, where and how?
Answer is no. Your Worship, the trial court will be asked to...
It's fine. Yes, it's more than enough as to what you have said.
Yes, of course.
Paragraph 13.
Paragraph 13 of Exhibit B.
Exhibit B.
As continues.
Is there any way that he's linking these other cases that we've mentioned here? Eldorado case 212/12/2021 as well as Rebecca?
The applicant is not personally named. It's the used firearm that is linked.
The very same cartridges that were found at the scene of the crime at Oslo-Ras, they are related to these two cases.
That is correct, Your Worship.
So I can conclude that they come from one fire.
According to the police report, yes, Your Worship.
addresses at the businesses, none of those was found.
Your Worship, the investigating officer was there personally, and he saw the business, but I don't think there was no inquiry about the address of the business. But the business are known, and their location is also known. Thank you, Bishop.
As the court pleases, Your Worship, may I quickly approach the accused on one aspect? Applicant, I apologize. Thank you for the indulgence, Your Worship. Your Worship, the issue of the address, we have visited on numerous occasions, and I submit that it has been resolved. The wrong address emanates from a lease agreement that the applicant entered into. It is not of his own accord that this was the address that was made available. Now, if the court looks at Annex D, which is the supplementary affidavit that was written by the investigating officer, AR02, there's a photo there, it's photo number 10. If the court looks at photo number 10, there's a jacket. It's that jacket that made waves from the Madlaga Commission, and at one point or another, it ended up being a meme. It's the same jacket that was worn by the applicant in the Madlanga proceedings. Now, this is the jacket that is found at the now correct address, which is 4544. I submit that it is not in dispute that the applicant resides at that address. The remainder of whether it's a 44, it's a 45, it's a 54, those are trivial issues. Where he resides has been established. Now, the state says that the applicant deliberately wanted to mislead it, or rather not provide the correct address. There's a PIN that was shared, and there's a business address that the investigating officer also knows about. Now, on those two aspects alone, and not looking at the other issues in completion, there is no way that one would have this and also act deliberate. The instruction is that both these streets that have been mentioned by the state are actually, one goes in another direction and the other one goes in another direction. Sadly, there's a photo that hasn't been discovered, and it contains a street sign which has got one street on this side and that street on this side. Hence the submission that they are minutes apart from each other. That is a difference that is not material, and the applicant ought not be denied bail on those reasons. Now, Your Worship, the state further says that the applicant is a flight risk because he was not available to give a warning statement. He was sought, he could not be found. The applicant has explained to the court that these engagements fell in the time frame where he had to go and appear before the commission. He was also uncertain as to whether or not this person that was calling him is a police officer. There were issues of safety that were of concern to the applicant. Now, further thereto, the state makes reference to circulation. I believe it was in 2002 where the applicant was sought, and that the court draws an inference that he is a flight risk because he was put in circulation. That issue has been dealt with. As the matter stands now, the applicant before court is not being sought for anything. He is not circulated for anything. The IO himself says that in his affidavit that he went to the place of residence and could not get him for a warning statement. And these are submissions that are made by the state. Now, what then becomes obvious is that where he resided has always been common knowledge. It's being evasive or difficult in not wanting to accept that there is an address and he can be found, in the hope that the applicant will be denied bail. This is the demonstration of how this is being conducted. The state further alleges that he was arrested only after he had testified at the Madlanga Commission. When he went to Madlanga, he had attorneys of record. If the state really wanted the applicant, they could have communicated with the attorneys and found him. And when they arrested him, members of the media were present, meaning that they also had knowledge that the arrest was to take place. My submission is that that was not somebody who was evading, who was caught because he was at that time on that particular day. The whole intention of that exercise was to embarrass Mr. Mogotsi. Now, Your Worship, Further, the state says that in the event that court grants bail, an amount of 100,000 rands is reasonable. I wish to reiterate that Mr. Mogotsi said in his papers that he makes 32,000 rands. That's his salary, that's what he earns. And those type of amounts would be unjust, and it would be unreasonable given his socio-economic circumstances. As the court pleases.
Your Worship, I will not be long. Your Worship will remember that we supplemented our papers, and when we supplemented our papers, there was a screenshot which was attached to the supplementary affidavit. That particular screenshot, which has the pin location that was sent to the investigating officer. If we look at this screenshot, the pin is on Mushu Street. If we look closely to that particular screenshot, it's on Mushu Street, that particular pin. Then when we look at the second attachment, where it shows the location of the actual house, even though the number is different, it shows Mohatla Close. That is in relation to the pin that was provided to the investigating officer. I'm not sure if the court is able to see because it's in black and white, but I have it in color, which is the reason why I can actually be able to see that there's a street name, which is Mushu, on the pin that was sent to the investigating officer, and then on the screenshot with the house, with the actual house, it's Mohatla.
Doesn't show Mohatla.
On the bottom, it's 4545, and then there on the bottom of the screenshot. I'm not sure if it appears.
Annexure OB 5.
Yes. I think it's 5 and 6.
Mushu, it's there.
Yes. Then 6 on the bottom, right on the bottom, Your Worship. Unless if the screenshot, Your Worship, did not.
At number 6 is Mokala.
It's Mohatla Close.
No, unless it ever maybe because of there is this arrow on top, it might have been.
Not. I see the arrow, Your Worship, but on the right at the bottom, where there's also 2 years ago, the picture taken 2 years ago on the bottom.
Where it says 45.
That's correct. That's correct, Your Worship. That is the name of the street. The screenshot is from the same pin location. And then I've listened to the argument about the state that at the Matlanga Commission, the applicant was appearing as a witness, and now he was being sought after as a suspect. But on the 3rd of March, when the investigating officer went to his house, he did not know that he was a suspect. And even if he knew that he was a suspect, and he had any reason to actually evade or want to evade, then he would have disappeared and no longer appeared at the Matlanga Commission, because it is public knowledge that he was going to appear on the date of his arrest. Because if we are saying that he was trying to evade the arrest or giving the warning statement to the investigating officer, if he knew on the 3rd of March that he's being sought after and he doesn't want to cooperate with the police, then he would have decided that I'm no longer even going to attend these particular commissions, because now I'm already aware that there's a warning statement that needs to be obtained, or there's an imminent arrest by the state or by the police. Then he would have decided to stay away. So that argument does not stand. Now, the issue regarding the statement and the giving of, or rather the failure to provide information, he made that particular statement with the advice of his attorneys who were representing him. The fact that he took 10 days before he submitted a statement cannot be an indictment on the applicant in this matter. It is clear that he indicated that he was in hiding. That is also in the investigating officer's statement. And he did the statement through the attorneys. So that particular point that he took long, perhaps an adverse inference should actually be drawn in relation to this particular time frame. It's baseless. That is all I have to submit at this stage. The court please, Your Worship.
Your Worship, there's only two aspects. That the issue of the Matlanga Commission charge that he was with. I think my colleague is testifying because really she cannot say that jacket is in fact the jacket that the applicant was wearing. The other thing, Your Worship, is then that it is not correct that the investigating officer went to the place where the applicant states to obtain a statement. He did not know where the place is. He only went to the business addresses. And I've also noted that my colleague have now changed that these numbers, they are not on the same state because it was submitted and this honorable court was informed that these numbers are on the same state. And now my colleague is now showing the honorable court about the pin and indicating that it is black and white. But earlier on, it was said that these numbers are on the same state.
I'm going to receive my judgment. Can we arrange the date? I'm available the 29th of May. Please send it over the office. 29th of May.
Your Worship, the date is in order.
Okay.
The date is in order, Your Worship.
Are you available?
That is tomorrow, Your Worship.
Yes. Yes.
If it's tomorrow, I can.
Sorry, my mind. No, let's give it a little postponement. It's similar. I'm actually looking at next week. My apologies.
Your Worship, we were just excited, Your Worship, for some time, Your Worship.
Next week, Thursday? The 4th.
The 4th is suitable.
Your Worship, I'm not sure. Your Worship, I think applicant wants to say something. May I just approach? Thank you, Your Worship. Thank you, Worship. Your Worship, the fourth is in order.
It's also suitable.
It is suitable, Your Worship.
Mr. Mkosi, please postpone to the 4th of June for court ruling. You are in custody, Mr. Down.
As a court uses.
Thank you, Court Adjourned.
All right.